Students, we will be starting our session today discussing on the last unit of the Constitution syllabus, that is elections and amendments. Two things we have to discuss today. One is relating to the process of elections in our country. Secondly, we are going to discuss about the amendment procedure and what are the important amendments which are done to the Constitution till now. For our study, we have only focused on some important amendments, not all the amendments. So, those amendments which have brought a drastic change or a modification in several parts of the Constitution or added something to the Constitution, we'll be discussing today. So, first of all, going to the chapter on elections, that is chapter 15 of the Constitution, articles 324 to article 329. These are the very important provisions. Why? Because we are a democracy, and a democracy is kept alive by conducting free and fair elections in the country. So that is the basis of democracy. So, what is the system in India wherein the election is regulated and it is controlled and it is managed and it takes place so that we are able to exercise our franchise and we are able to elect those leaders who are our representatives who form part of the government in India. So, first of all, Article 324. If there is any doubt, anybody wants to ask any question, you can type in the box or you can even ask me. Hope you are able to listen to me properly. Am I clear with you all? Okay. So I will start with the Election Commission of India, Article 324. This is a constitutional body, and this body consists of the Chief Election Commissioner and some other election commissioners. It doesn't say, the Constitution doesn't specify the number, but the President can appoint one Chief Election Commissioner and such other election commissioners along with, they don't say assistant or they don't say deputy. It says that other election commissioners as the president may fix from time to time. 324 says that there shall be an election commission of India consisting of a chief election commissioner and such other election commissioners which the president may appoint from time to time. So that is the 324 subclause 1. Now, what is the functions of this election commissioner or election commission? Totally, the election commission. Same way we have a state election commission where the governor has the power to appoint the state election commissioners, to which forms the body for the state election commission. Now, when we come to the central election commission, article 324 subclause 1 to subclause 5, it states about the powers and functions of the election commission. Now, this powers and functions of the election commission are in 3 words. You can summarize that. It says that the superintendence, direction, and control of the elections is the function of the election commission. So he is in charge of the superintendence, direction, and control of the elections. So for that, when we expand those words, what are the functions that he performs is, he prepares, number one, he prepares electoral rolls for the elections to the parliament and state legislatures as well as the local bodies. All bodies, local bodies, wherever elected leaders are appointed or are elected, and all the state legislatures where the members of state legislatures are elected, and the central legislature, that is the central parliament, where the parliament members are elected. For all this, he means the commission prepares electoral rolls. Then, secondly, The Election Commission lays down the general rules for the conduct of elections, all the rules and regulations which are required for the conduct of elections, and it issues the notification dates, and it issues the schedules of election, and it ensures that the election papers or the nomination papers are secure. So for that matter, whatever is required, appointing of people, getting the things done, all these things are within the control of the election commission. Then, third, the Election Commission determines the code of conduct to be observed by the candidates and by the parties during the election. You know that at the time of elections, there is a code of conduct. So, what they should do and what they should not do. These things are decided by the Election Commission. Then, the Election Commission recognizes parties. So when the election commission uh, allots the symbols to the parties, it gives them the symbols, it gives them recognition, and gives them the permission to form a party and conduct the elections in the name of the party. So that is the function of the election commission again. It allots symbols and accords the recognition to the parties. Then the election commission also gives advice to the president on certain matters. Which are the matters? The matters relating to disqualification of members of state legislatures and of the parliament. See, the election commission advises the president or the governor on these matters, because I had told you when we were discussing the function of the president and the governor that they have the power to disqualify the members if they are not following the rules of the election, or if they defect from the party after the election. See, these are the grounds. So, if a member has to be disqualified, the advice is given by the election commission to the president or the governor, and they act accordingly. They may follow his advice and his recommendation, and they may take the steps necessary to disqualify the members of parliament or the state legislature. This is the function of the election commission, to give advice. Then, suppose there is a situation where the election has been declared, but it cannot be conducted according to the schedule. Then the election commission has the power to postpone the election for a particular period. The election commission can postpone election for specific mandates. Specific mandates means specific reasons why the election cannot be conducted. He will be specifying and notifying to the public. Then the election commission also appoints election officers for conducting the elections. All the officers are appointed through the election commission, and all the disputes arising due to elections are also looked after by election officers who are appointed by the election commission. So election commission appoints election officers. So what are his functions? He superintends. The election commission is in charge of superintendence, direction, and control of elections. The election commission prepares electoral rolls. The election commission lays down general rules for election. The election commission determines the code of conduct for the parties. The election commission recognizes the parties, allots the symbols to the parties. The election commission renders advice to the president and governor relating to disqualification of members, and the election commission postpones the election for specific mandates and appoints election officers to decide matters of relating to disputes which arise out of the elections. Is it clear what is the functions of the election commission? Have you understood this? Yes, is it clear that the election commission has a plethora of functions, and these functions are exercised independently? It is a independent constitutional body. Yes. Any doubt relating to this? Any question relating to this? Anybody? Or is it clear? Karthik? Rahul? Am I clear? Because I want you all to understand this. It may see these questions specific. Okay, Karthik. So I have been doing this notes actually, which I will be sharing with you. But the purpose is that you should be able to write the answers if it is asked in a theory form in the examination. So, what are the functions of the election commission? What is the electoral procedure in India? These are the probable questions which could be asked. I'll be also uploading the question bank in a short while. So you can look into the question and prepare the answers for that. And even relating to the multiple choice questions, we can ask a question like, this is not the function of the election commission. So you should know what are the functions of the election commission to know what is not his functions. Okay, so anything which goes outside this, I could ask something which is not his function. See, function, what is the function of the election commission? Basically is to superintend, to conduct, to control, to direct the elections. You should know this. Then, see, election commission is appointed by the president, but there is one important function which the election commission doesn't exercise, but the president exercise. That is declaring the elections and notifying the election. So, notifying the election at the first instance is the function of the president when it comes to central elections, and when it comes to state elections, it is the function of the governor. So, it is a notification which comes from the president or governor. Then the election commission's functions start. So I could ask you the question that notification of elections or declaring of elections, which is not in his functions. Okay. So some other functions could be given, allotting symbols or preparing electoral rolls. So you should be prepared for those answers. Okay. So now coming to the electoral procedure. What is the electoral procedure? Actually, how the elections go on in our country. First of all, the election commission has to decide the schedule of the election. See, what happens is, in the beginning, the government recommends to the election commission. There is a recommendation of the government to the election commission that we can have election at a particular period. Of course, there is a term of the parliament. There is a term of the Lok Sabha for 5 years. At the end of 5 years, you should have a election for the Lok Sabha. Again, there is a term for the state legislatures. They may have come into any time of the year. So within the 5 years, immediately after 5 years, when the state legislative assembly dissolves, it is necessary to conduct the elections. Sometimes it happens that the Lok Sabha or the state legislature dissolves before the 5 years also. In such conditions, declaration of elections has to be recommended by the government to the election commission. Then there are local elections of the panchayats, or local elections of the local bodies, or some other, it may be also members to the Rajya Sabha. So all these things are first of all recommended by the government to the election commission. Then the election commission decides the schedule. They decide the schedule so that one election does not clash with another. Secondly, it should not be a burden on the economy. Thirdly, it should be smooth, and the system should be functioning well, so that there is smooth and fair conduct of elections. All these matters have to be looked into by the election commission. Now, as the president or the governor declares or notifies the date, notifies the elections, then once the notification of the president or governor is done, the election process starts. Then after that, 8 days are declared. See, then the election commission declares the dates, and the 8 days are given for filing of nomination papers of the candidate with respect to two conditions. First is, the candidate must be a voter in the country. He should be a voter in the country. Secondly, the candidate who stands for the election must be qualified to be a candidate, as he should be a member of the concerned constituency where he is contesting. Now, you may ask a question that sometimes a candidate can contest from two or three constituencies. It can be that a candidate has a right to contest from two or three constituencies also. He can do so, provided he is a member, he is enrolled as a member of that constituency. He has to enroll himself first as a member of that constituency, and then he can contest for that constituency. Then, third, after the nomination, now 8 days are given for nomination. After the nomination papers are filed, then the returning officer, a person who is appointed as a returning officer, he examines the nomination papers and he sees if there is any defects in those papers which are filed by the candidates. If there are any defects, he could reject the nomination papers. On that ground itself, the nomination papers could be rejected. Then, after the examination, 2 days are allowed. 2 days are allowed to the candidates for withdrawing them. Suppose they feel that after nomination, after filing the nomination, they are not wanting to continue or wanting to contest the elections, they can withdraw their nominations. And for that, 2 days are given for withdrawing the nomination papers. So these 8 days, 2 days, these are the keywords where you can be asked questions in multiple choice questions. Then finally, the returning officer finalizes the list of the candidates, and after that, 20 days time is allowed for campaigning for the elections. So the candidates can campaign based on their manifestos, based on their policies, or whatever they plan to do after the election. They can woo the voters. So for that, 20 days are given. Then after 20 days, anyway, even after 20 days, see, at the time of the election, whatever is the date for the election, before that, the campaigning should stop. How many hours before the campaigning should stop? Anybody has an idea? Campaigning for elections, how many hours can it stop before that? What is the 48 hours? Very best, very good. So 48 hours is the time within which the campaigning for the election should stop. So after this, the election takes place, and then, as after the election, keeping of the ballot papers, preserving them securely, and then afterwards, so there is a date announced for the counting of the votes. The date when it is announced, to take help of the police and provide for the security for the papers and for the counting procedures. What are the things, what are the code, what is the code of conduct during the counting? Also, it is decided by the election commission, and the election commission has several powers in this case, and it is an independent power. And there, after the counting of the votes, the majority, the party which has the majority is announced, and the person who is elected, the people who are elected, the candidates who are elected, the names are announced. So the functions of the election commission continues for the elections from the date of announcement of the election by the president or governor, as the case may be, till the date when the candidate has been elected, declared elected. So this is the process of elections in our country. Okay. Now there are, as it is a democracy, we need to have free and fair elections. So there also has to be several reforms in the matter of elections. So we know that earlier we used to have ballot papers. Now we have ballot papers, but now we are having EVM machines. So preserving of the machines and keeping them in good order, and if any complaint comes into, then looking into that complaint, appointing officers for that matter. See, the plethora of functions of the election commission can be discussed in this manner. So much has been done to bring electoral reforms by one act. There is one act, Representation of People's Act of 1951. It's a very old act, but it has been amended by introducing several new things in that, because we are having now, science and technology has given us several ways of having or addressing some issues. So the Representation of People's Act of 1951, first of all, it gives the qualification and disqualification of the candidates. First of all, who is qualified to be a candidate in election? We know that everyone has a right. We have political justice stated in the preamble. So everyone has a right to stand for the election. Besides that, also, every person who stands as a candidate has to be open with his details. That means he whatever his information is there relating to his finances, relating to his property, all these has to be mandatorily put in before the public before he is selected for the candidates post. That is a mandatory provision now made under the Representation of Peoples Act. So we are having several things which are introduced in the Representation of Peoples Act. So this is relating to the elections in our country. So if there is a whole question, it could be relating to the functions of the Election Commission, or it could be relating to the electoral procedure in India. If it is electoral procedure, it starts from the notification of the president and the whole procedure has to be stated. Then if it is speaking about the functions of the Election Commission, then you need to tell that the functions of the Election Commission in short. That would be a theory question for 5 marks. Okay, so now going to the next important provision which is there in our constitution, which we have already discussed in short when we have discussed the preamble and we have discussed certain fundamental rights. See, the important provision in our constitution when we say that our constitution is not rigid, it is flexible. Why it is flexible? Because it is we can amend the constitution from time to time if it is necessary. This provision is made because if you make a document and keep it static without changing, then there may be certain changes in our country further which we have not seen now. At that time when the constitution was made, the leaders were aware of the situation in the country at that time. There may be so many science and technology improvements, developments in the country, which may need for several changes in the constitution. There may be certain social situations in the country which may need for some change in the situation, or there may be certain developments in the political arena where you need certain changes. So you cannot make a constitution written and rigid. It has to be flexible. But how flexible should you make it? Any person who wants to put forward his policies, he is elected in by majority, and then he comes to the post of important post of a prime minister or a minister or a president. And if there is a majority party which is ruling, then by majority they can make any changes as they wish. If the procedure to amend the constitution is very easy, then it would be easy for the ruling party to make changes as they wish, which is not desired by the founding fathers of the constitution, or which may be not we can say not approved by certain norms of our constitution. So what happens is we have made it not so rigid, not so flexible. We have made the procedure of amendment in such a manner that certain matters which are easy to amend, certain matters, for example, under Article 2, the Parliament can admit a new state in the Union. For that, it doesn't need much debate because it's good to admit a new state in our Union. It's not going to harm any particular state or harm any particular citizen there. So again, under Article 11, Parliament has a power to acquire, to make a provision for acquiring citizenship or termination of citizenship. So there, the power of the Parliament, because the Citizenship Act itself is a central act, and to make any changes in the provision of the Constitution relating to that, it has been given to the Parliament. So in such cases where it is easy to amend, that means Parliament can, by simple majority in the house, both the houses, of course, both the houses, simple majority, that amendment bill can be passed, and it can amend the constitution. Then other matters like privileges and functions, privileges of the members of the Parliament can be amended in this manner. Then changes in Schedule 5 and 6 that deals with the tribal areas, because tribal areas are under the hands of the Parliament itself, under the central government itself. The Parliament can make changes by a simple majority. Then creating legislative councils for the states. If you know that there are only five states which have a legislative council. Other states have only legislative assemblies. We have a bicameral parliament at the center, but at the state we can have one house also. So in such cases, what happens is, just a moment. Yes. Charge बैटरी बैटरी ऑफ केलं तुम्ही. Yes. To continue, some provisions are easy to amend by simple majority. That is, if a legislative council of a state has to be created under Article 169, then that state can pass a resolution in its state assembly and forward that resolution to the center, that is to the parliament, and the parliament can make a can create a legislative council for that state under Article 169. That also amendment, that is creating a legislative council for the state, can be done by simple majority. So these are the powers of the parliament to create or do certain things by simple majority. Is there any question here? See, for amending the constitution, there are three different kinds of amendments, that is amendment procedures. This is Article 368. Please take down. Article 368 speaks about the amendment procedure. Not only amendment procedure, power and procedure to amend the constitution. So power and procedure to amend the constitution is stated in Article 368. There it provides for three procedures. So one is by simple majority, which is which provisions are directly under the control of the parliament, central parliament or the union. They can amend by simple majority in the parliament. Secondly, by special majority, there are certain matters which are under the hands of the union government, but also they need the concurrence of the states. So if such matters, if it has to be discussed, then the parliament has to pass that bill by special majority. See, what is the difference between the simple majority and special majority? Can anybody tell me? Yes? Pranav, can you tell me what is the difference between simple majority and special majority? If a bill is passed by simple majority, what does it mean? And a special majority, what does it mean? Yes, Sharad Chandra? Uday? Anybody? Okay. So, simple majority means just it is a 50%, and if it is 51% and 49% only. See, for example, out of 100, if a 51 say yes, it is a simple majority. Special majority means at least 2/3 of the members who are present and voting. 2/3 of the members who are that is a majority of the whole house, and 2/3 of the members who are present and voting should say yes to that amendment. That is called as a special majority. So certain matters can be passed by special majority and amended. Then the third way, see, for example, there are certain matters where for example, matter of distribution of funds between the union and the states. So there the states are also involved, or changing certain important provisions which may affect the state also. So the powers of it may be the powers of the president, it may be the powers of the governor, it may be relating to the powers of the chief minister or the prime minister. So these are the powers which affect not only the center but also the states. So there, in such conditions, then there is a provision that the parliament should pass the amendment bill by special majority first, and then it should be sent to the state legislatures. And all the state legislatures, how many states are there in India? Out of them, at least 50% of the state legislatures should say yes. That is, they should ratify the bill. Ratification of the bill means, ratification means once the thing is done, first the first step is over, then the consent is obtained after that to that. So suppose some act is done and later on they say, yes, we agree with you, whatever you have done is proper. That is called as ratification. So once the bill is passed by the parliament in by special majority, it is sent to the state legislatures, and at least 50% of the state legislatures, that is half of the state legislatures, not half of each state legislature, half of the total states. How many states are there in India? Half of those states have to say yes to the amendment bill. Then that bill will be stated to be amended, and the constitution will be amended when that bill is ratified and then assented to by the President of India. After the amendment, then the constitution stands amended. That is why we say first amendment, second amendment, third amendment. Every amendment is given its own identity. At that amendment, what happened to the constitution, what were the changes which have been affected. Now there was a question earlier that whether the fundamental rights can be amended in this way, because fundamental rights are very important to us, and if the fundamental rights are not amended, then are amended, then the citizens may have a certain restrictions imposed upon them. So that is why the question whether fundamental rights can be amended came up when they decided to amend the provision relating to right to property. You know that right to property was a fundamental right earlier. They decided to remove that from the fundamental rights chapter and put it in another chapter where it doesn't remain a fundamental right. There is a difference between the two rights. So they decided, because several law reforms were introduced in India. In the beginning itself, they decided to remove the zamindari system, and they introduced the law reforms where the people who were holding a large amount of assets or property, their property was taken over by the government and distributed to the those who are in need of. So, in that way, the fundamental rights were affected. Then, law reforms were introduced everywhere. So, property reforms were introduced all over India, and then there started coming a lot of cases concerning the right to property, which is the fundamental right. So, they decided to remove the right to property and put it in some other. Of course, it is a right, but not a fundamental right. To put it into another chapter. So this was questioned by several people, and many cases came up to India saying that fundamental rights cannot be amended. You can amend any part of the constitution, but you cannot amend the fundamental rights because they are important rights of citizens under the constitution. They are not given by the state; they are inherent rights. So this gave rise to several cases. We are not discussing all the cases, but one important case we have already, I've given you the name, already we have discussed, that is Keshwananda Bharati versus State of Kerala. In this case, the question whether fundamental rights can be amended was before the court. Then, not only that, but how much can be amended? Then, can anything be amended in the constitution? What things can be amended in the constitution? Whether constitution totally can be amended? What is the scope of amendment? That was discussed in this particular case. In this case, the Supreme Court laid down that the fundamental rights could be amended because there is Article 368, which does not say anything that fundamental rights cannot be amended or it can be amended. They can be amended if there is a condition or if there is a situation in the country where it is required that a certain rights should be amended. That can be done because the power to amend is there in Article 368. So even under the word law in Article 13, we don't have any what you call as any restriction that you should not amend this fundamental rights. But they say that any law which takes away the fundamental right is void. But if that law which takes away the fundamental rights is void, correct. But if the fundamental right itself does not remain, can that law become void? Was the question. They had introduced one ninth schedule to the Constitution by the First Amendment. First amendment came up in 1951. Please remember, first amendment came up in 1951 when the law reforms relating to property was introduced, and they put one schedule in the constitution, that is 31A and 31B were added after article 31. 31 relates to right to property, so it came up there. And then after that, after 13B, they introduced one schedule, and they said that any law which is put in the schedule cannot be questioned before any court that it is violation of fundamental rights. They put that in that schedule. So the people question this in this case. So in fundamental right, that is why Keshwananda Bharati versus State of Kerala is called as fundamental rights case, where the fundamental rights were discussed. So there the court said that there were 13 judges in this particular judgment who have written a vast judgment giving the importance of fundamental rights in the constitution, and they said that nothing can be amended except which is necessary under the constitution. Even if it is a fundamental right, it can be amended, but they put one condition. They said that you can amend anything in the constitution except that you cannot remove the basic structure of the constitution. So what is the basic structure of the constitution? All those things which make up the basic, what you call as a system of our government, system of our constitution. For example, they said secularism is our basic structure, sovereignty is our basic structure, democracy is our basic structure, justice, equality, liberty, fraternity, this is the basic structure. The court referred to the preamble of the constitution, and the court said in this case that the preamble is the key to open the minds of the makers of the constitution. This was stated in this case, and the court said that we can remove anything from the constitution, but we cannot remove the basic structure. For example, if you have to modify a building, if you want to repair your building or your house or a structure, what you do is you can make certain changes, you can modify, but you cannot remove the foundation, you cannot remove the basic structure which makes up your building. If you try to remove that or you try to amend that, the whole building will collapse, whole structure will collapse. In the same way, the things which form the basic structure of our constitution cannot be removed or amended by a amendment procedure. That was a very important judgment where the court has introduced the concept of a basic structure. So I could ask you a question. Basic structure theory was put forth by the Supreme Court in which case? So that is the Keshwananda Bharati versus State of Kerala, where the basic structure theory was put forth, and it became very famous not only in India but all over the world, that basic structure of the constitution cannot be amended. So this is the judgment which is to be studied with reference to the amendment of the constitution. Now let us look into some important constitutional amendments. As I just now told you, the first amendment took place in 1951, where you can just note down those provisions which were amended. See, in first amendment 1951, the article 31A and 31B was introduced, and 9th schedule was introduced so that the zamindari system could be removed. Then came the 24th Amendment Act. The 24th Amendment Act of 1971, wherein Article 13 and Article 368 were amended. Why 368 relates to amendment itself. So what they said is, in the amendment 368 provision, the marginal note was procedure to amend the constitution. They changed that and they made it power and procedure to amend the constitution. So power is there to amend, to show that. Okay, and they also added in Article 13, they amended saying that power to amend the constitution is there. Then coming to 25th Amendment was the third amendment, which is important, in 1972. In 1972, Article 31 was amended by substituting the word compensation for amount. See, in Article 31, if the government takes away the property for the purpose of public purpose of any person, then that person has to be given certain amount in lieu of his property. That amount word was there. They changed it to compensation. That means a proper amount should be given for him to compensate for his property which is taken over by the government in Article 31. Then 31st Amendment came in 1972, wherein by this the representation of the states in the Lok Sabha, how many states, how many people should be there to represent in the Lok Sabha, that was increased. That means the total number of members in the Lok Sabha earlier was 525. They made it to 545 members. And in the union territories, it was 25 members. They brought it down to 20 members. That was the amendment in 1970, 73, that is 31st Amendment. Then coming to the very important amendment in 1976, that was just at the time of the emergency when it was going to be imposed, all those things were taking place. So in 1976, the 42nd Amendment was brought in. So after that, of course, the emergency was imposed and all those things happened. But in the 42nd Amendment, certain important things were done. First of all, we have discussed that in the preamble, two words were added: socialist and secular. Two words were added. That is, we had said that constituting India into a sovereign democratic republic. They added sovereign, socialist, secular, democratic republic. That is the 42nd Amendment of 1976. Please remember this amendment. And then the preamble was amended. One more thing was amended in the preamble, that is unity of the nation was there. They added unity and integrity of the nation. Two words, and integrity also was added in the preamble. This is the first one. Then next, the members of the parliament, if they were to be disqualified, the president could decide about the members of the disqualification of the members with consultation with the election commission. They added that he has to get the advice of the council of ministers if he has to disqualify the ministers or the members of the parliament. That was added. Then also Article 74 was amended, saying that the president has to act according to the aid and advice of the council of ministers. So the president's powers were curtailed. Again, in the state also, governor's powers were curtailed. So this was a very important amendment. That is why that is the same 42nd Amendment. Then the center and the state relations. For example, we have a list, the state list and the concurrent list and the union list. So in that, certain things were introduced. For example, from the state list, they took out education, forest, wild animals protection, and birds, protection of birds, weights and measures. They were removed from the state list and they were put in the concurrent list, so that both could make state or center could make laws on that subject. That was done. Then after that, emergency provisions. For example, the president could declare emergency throughout the country and not only in part of the country. That was the earlier provision. They added that either in part of the country or whole of the country, the president can declare emergency under Article 352, that is national emergency. Then also they added one Article 31C by the 42nd Amendment, that is the directive principles. If there is any question where the directive principles and the fundamental rights are clashing with each other, then the directive principles will have priority. That was given. That was put in the 31C. Then again, a new article was put in the directive principles. That is, new articles like 39A, 48A, and 43A. We have already discussed these provisions. So these were added in whatever was 43. They added 43A. 48, they added 48A. In this way, they added articles, and then they added one important part, that is the fundamental duties. In 51A of the Constitution, they inserted 51A and they added the new chapter on fundamental duties, which was not there earlier. That way, they put in 10 fundamental duties of the citizens of India in the 42nd Amendment. These are the different things. So I could ask you a question: what is the most important amendment in India, and what are the different things decided under this amendment? So if that is the case, you have to know all the amendments which have been taken place in the Constitution by the 42nd Amendment, and 44th also was a very important amendment. We will come to the 44th Amendment. As you know, 44th Amendment itself removed the right to property from Article 31 and also Article 19(1)(f). 19(1)(f) said that all citizens have a right to hold, acquire, and dispose of property. Okay, so this was a fundamental right because it was a fundamental freedom under Article 19(1). You know that Article 19(1) gives the fundamental freedoms of all citizens. This was removed. This was completely removed. Then there is another article which we already discussed when we were discussing fundamental rights, which is repealed. I told you that you make a note of this, so we'll be discussing later. That is Article 31. Now we don't have Article 31. We have Article 31A, B, and C. Article 31 said that no person shall be deprived of his right to property except according to the procedure established by law. That was Article 31. They removed this Article 31 completely deleted, and it was put one more article was introduced or inserted in the constitution after 300. Article 300A was introduced, in which they put this particular provision there. So now we have Article 300A, where it says that no person shall be deprived of his right to property except according to the procedure established by law. We have this, but it is not a fundamental right because it is not in Part 3. They made this amendment by the special procedure, that is in 44th Amendment to the Constitution in the year 1978. This is a very important provision. Two amendments: 42nd Amendment 1976, 44th Amendment 1978. These two provisions are very, very important. Okay, and then one more important thing was introduced here, which we discussed in the emergency chapter. In Article 352, national emergency earlier could be declared by the president on the grounds of war, internal disturbance, and external aggression. These were the three grounds. Now, what happened is, because of this word internal disturbance, several things took place. Because when people started complaining or criticizing the government policies, on that ground, the government said that there is internal disturbance and there was an emergency imposed on the people. So, many things happened in the emergency, which led to the formation of a new government at that time. And then the emergency was taken back, and all those things happened. So to see that this does not repeat again, that internal disturbance word was removed, and they put in the word armed rebellion. So now under Article 352, the president can only declare a national emergency only if he is satisfied that the security of India is threatened on the three grounds. That is, one is war, one is external aggression, and third is armed rebellion. So armed rebellion was substituted for internal disturbance in this particular amendment. This is very important. Okay, this is the 44th Amendment of 1978. Then one more Article 359 was amended. That is, earlier, see, president could suspend any of the fundamental rights of citizens during an emergency. That was the provision. So when there is a right to life, suppose a person is arrested without any reason, or suppose a person is put behind bars without any reason, or Article 20 is violated, 21 is violated, 22 is violated, what happens? So for that, they introduced a further provision, subclause in Article 359, saying that the president could suspend the fundamental rights under the Constitution during emergencies, but he cannot suspend the fundamental rights under Article 20 and 21. So now right to life cannot be suspended by the president. Then right to the convicted person, relating to certain, whenever a person is convicted of offenses, what are his rights? Those rights cannot be suspended by the president. Those rights remain even during emergencies. All these different amendments took place in the 44th Amendment. Please remember, removing of right to property, then introducing of article of a ground in Article 352 emergency, then 356 under Article 356 state emergency, it can the emergency can remain for at least maximum 6 months. Earlier it was 1 year. That was changed to 6 months. All these things remained. Then one amendment which was done in the 44th Amendment, that was removed. For example, the president has to consult the Council of Ministers if he has to decide about the disqualification of ministers. That was removed again. And it was now the president can disqualify the ministers or any member of parliament with the consultation of the election commission. So as it was earlier, it was restored, because if you consult the ministers, then why they will advise him to disqualify. So that is a absurd provision, so they removed it. Okay, so this was done by the 44th amendment. The next important amendment is the 52nd amendment in 1985. 52nd amendment is the amendment where a new schedule was added to the constitution, that is the 10th schedule. In the 10th schedule, any person who changes his party after the election, he is said to have defected from his party. Such person can be disqualified from the remaining member of the parliament. That was stated in the 10th schedule, and it was made a law that is called as anti-defection law. That was introduced in 1985. Any doubts relating to this provision? Please ask me any doubts if you are not clear, if I'm going too fast, or if I'm not clear with what I'm saying, or if you are not able to understand. Please, just you can type here if you have any questions. Is it clear? Then the next important amendment was the 61st Amendment Act of 1989. Okay, 61st Amendment of 1989 reduced the voting age from 21 years to 18 years. Earlier it was 21 years, it was made as 18 years. Then there were two amendments in 1993, 73rd and 74th Amendment, where by 73rd Amendment, a new Part 9 was introduced, which spoke about the panchayats, gram sabhas, and which have to be compulsorily constituted in the villages. So, in a group of villages, gram sabhas, panchayats in the rural areas. That is chapter 9. Part 9 of the Constitution was introduced. 74th Amendment, Part 9A was introduced, which deals with the powers of municipalities and municipal corporations. There were three different things: municipal councils, municipal corporations, and municipalities, which were created in urban areas, smaller urban areas, larger urban areas. They were classified. That was introduced in Part 9A. So 9 and 9A, Roman 9 and Roman 9 capital A, these two were introduced by the 73rd and the 74th Amendment, both in the year 1993. After that, in 1995, after the Indira Sauni case, Article 16(4)(a) was introduced, where promotion matters for scheduled castes and scheduled tribes, which the Indira Sauni case said that no promotion reservation can be given. But they introduced promotion provisions, that is a reservation in promotion for scheduled castes and scheduled tribes, by adding 14A to the Constitution. Then 4A to Article 16. Then 86th Amendment of 2002, Article 21A was inserted. Article 21A was inserted by inserting right to education. Article 21 speaks about right to life. The court had already said that right to life is means also right to education. It also includes right to education in Unni Krishnan case. But again, one more article was introduced in a form of Article 21A, which says that every child from 6 to 14 years shall have the right to education. So that means that the state has to make provisions for this child from 6 to 14 years for education. So that Article 45 was substituted in the Directive Principles also. 21A was introduced. 45 was introduced, saying that the state should give free education for children from 6 to 14 years. Then one more 51A for right to education was 51A fundamental duties. In that, one more duty was introduced in 51AK. So we had only 10 fundamental duties. 11th duty was introduced, that any person who has a child, or any guardian who has a ward, so such a child should be sent to school. That means he has to, who is a parent or guardian, should provide opportunities to his child or ward between the age of 6 and 14 years. That was introduced in Article 51AK. Then The next important amendment was in 2003, 91st Amendment, which said that the size of Council of Ministers should be 15% of the size of the Parliament or state legislature. That to bring down the size of the Council of Ministers, so that more ministers should not be introduced. So it should not exceed the members of Parliament. So it should be limited to 15%. That was made in the 91st Amendment. So these are all the amendments, important amendments of the Constitution. Please be aware of each and every amendment. Also be aware of, please study the different things taken place in each important amendment, especially the 42nd and 44th Amendment are very important. Whatever the changes in the Constitution can be discussed looking into these provisions. So today we have completed the study of your syllabus of the Constitution of India only. In the next class, we will be discussing about the scope and aims of engineering ethics, which is the last part of our Constitution. That is the last unit, wherein we will be discussing what is professional ethics, what is the responsibility of engineers, what are whether ethics is necessary in engineering, and what are the impediments to these ethical problems, what is the meaning of ethics, and how engineers are able to face the problems which they come across in their profession. So these are very important things for engineers to discuss. We have ethics in all fields. So this is to be discussed in the next class. So we will have our next class probably on uh, Monday. Okay, on Monday morning. So if I decide to prepone or postpone, we will discuss about that with your CR, and we'll decide about the dates. Any doubts is there relating to these provisions, please tell me. And all of you, please type your names and your USN numbers so that I can give you attendance for today's class. And the attendance is being recorded, the class is being recorded, and this will be part of the record for your CIE, and which will be helpful for you for your SEE exams. So after this, please see that you are well versed with all the provisions what we have discussed till now. If any doubt is there, I'm repeating that again and again. You can write, post in the classroom, and all be present in the classroom. It at any time I can call your names. I can see that you are actively attending the classes, and I can note down. I can give you, you know, the notice will be taken of anybody who is not attending actively. So please be very actively attending the classes, and please see that you convey whatever your doubts are or whatever your issues are relating to the subject. Thank you very much.